They didn't say I know there's a lot of emotion surrounding January 6th, but these defendants weren't saying, and so we're going to go stage a coup.
All rise. Court 18 is now in session. Honorable Judge Mary Kay Holthus presiding.
Morning. Good afternoon. Good afternoon.
Please come over and be seated.
All right, whenever you're ready, folks. Oh, can we call it? Can we call it? You're not there, right?
Thank you, Your Honor.
What does it say?
Okay. State of Nevada versus James DeGraffenreid, C23379-122-1 through 6.
Does she need to call the defendant?
State of Nevada versus Durward Hindle, C23379-122-2. State of Nevada versus Jesse Law, C23379-122-3. State of Nevada versus Michael McDonald, C23379-122-4. State of Nevada versus Sean Meehan, C23379-122-5. State of Nevada versus Eileen Rice, C23379-122-6.
Good afternoon, Your Honor. Alyssa Engler and Matthew Rashford for the state.
Maggie McLetchie for defendant Jesse Law, who is present on Zoom.
Monty Levy for Eileen Rice. I request our presence be waived today.
Any objection?
No objection.
Hearing Arnold Marquis Arbach on behalf of defendant Sean Meehan.
Brian Hardy with the law firm of Marquis Arbach on behalf of Jim Hindle.
George Kelesis, Your Honor, on behalf of Mr. DeGraffenreid.
Richard Wright for Mr. McDonald, who's present by video.
All right, now you're ready.
Thank you, Your Honor. The evidence, including the supplemental evidence focused on by the state, shows that defendants didn't forge anything or try to trick anyone into accepting their certificate as the real thing. As discussed at the last hearing and as detailed on page 3 of our supplemental brief, they didn't use the state seal on the certificate. They didn't include a certificate of ascertainment because they would have had to have the Secretary of State sign. If they had forged the Secretary of State's signature on a certificate of ascertainment, we would have a very different case today. But instead, all the defendants did was express dissent with the state of Nevada's official 2020 election rights. They preserved the right to be electors if there was some official determination by a government body that Trump, in fact, had won. They did so by making the legal argument that they had, in fact, won and were the correct electors, never by pretending the state of Nevada agreed they won. In this country, we're allowed to debate and legally contest questions such as, first, whether there were sufficient irregularities in Nevada's 2020 election that the state of Nevada, such that the state of Nevada's official results should be reversed. Second, when the deadline to complete legal challenges was, January 6th or the safe harbor date. Incidentally, in the Gore v. Bush decision, 4 people, including Justice Ginsburg, said that it should be January 6th. Third, what role does the Senate play in elections under the 12th Amendment? Supreme Court justices and constitutional law scholars disagree about these types of topics all the time. The defendants are certainly allowed to do what they did, which is assert their legal views about the 2020 election and engage in political theater related to that, their efforts to preserve their ability to challenge the election in order to bring attention from the public to their concerns about the election. From the start, the state's effort to try to punish this disagreement and criminalize what is criminal has been trying to fit a square peg in a round hole. Nothing fits because there is no falsity or forgery, far from trying to trick anyone to anything. All these things that the defendants did, they publicly did. They publicly stated exactly what they were doing. They publicly acknowledged that they had lost the Nevada Supreme Court case. It would have been impossible to trick anyone. The idea, for example, that Vice President Pence or Senator Cruz didn't know who the official electors were from the state of Nevada is laughable. The state's evidence in support that they filed today in support of the purported evidence of intent doesn't show any relevant intent. Instead, it cements the reality that the goal of the prosecution is nothing other than punishing political disagreement. To walk through it, first, they rely on Exhibit 1 and the memorandum and the fact that they submitted these documents. But again, the fact that the defendants made the assertions they did on their electoral certificate without some kind of caveat. But the fact that attorney electors,
It would have been really easy to do.
it would have been easy to do, but it wasn't.
Others have done it.
Others did it. Others did it. It's true. There were lawyers that were electors in the state of Pennsylvania, and they thought of that issue. Lay people, they got instructions from Chesbrough, and they followed those instructions. And it's true that some other people did it. There were lawyers that were electors in Pennsylvania, that asked for language. The electors in New Mexico happened to get the same language, and
Which, if I'm not mistaken, is the only reason they determined there weren't criminal charges.
and they found that there was not evidence, and that was
Because of, my understanding is they found that the conditional language negated the intent. It would be real easy if y'all just had that here.
well, the question today, and it's true that language could have been included, and it would have been included, and the grand jury, Mr. Wright will discuss the evidence that wasn't presented to the grand jury about exactly why that language wasn't provided in Nevada and wasn't included in Nevada. But even without a caveat, nothing on the electoral certificate they submitted shows anything other than them preserving the legal argument that they had won. Again, they didn't submit a certificate of ascertainment. The state also relies on the fact that they knew the Supreme Court didn't side with them. But again, they are entitled to assert their own legal position and disagree with the official results, including the Nevada Supreme Court decision. And again, Mr. Wright will discuss the exculpatory evidence, but what part of the video that wasn't shown to the grand jury shows my client, Mr. Law, explaining that they are taking this to the courts. They never made it a secret that they were not the official electors from the state of Nevada. They never made that a secret. They didn't try to trick anyone. Another example of what the state relies on as evidence is the fact that I think it was on November 30th, before they had lost the case at the Nevada Supreme Court, that they asked Mark Voloshin at the Secretary of State's office to correct the certificate of ascertainment to reflect their correct names. The state claims that somehow this shows that they were preparing to commit fraud. Mark Voloshin actually testified that he understood wanting the record to be correct, and although he might have been slightly annoyed by it, he in fact corrected the public record. And the state can't seriously argue that ensuring public records are accurate. They weren't asking to be listed. They didn't ask Mark Voloshin to list them as the official winners. They asked him to list them as the Nevada GOP electors. And asking the government to correct errors in public records and ensure that the correct names are on a public document can't be evidence of intent to defraud. And again, as I pointed out earlier, they didn't send in one of the required documents that comes from the Secretary of State to the federal government, the certificate of ascertainment. They wanted to comply as best they could. They did not want to commit forgery or fraud. They didn't try to forge the Secretary of State's signature on a certificate of ascertainment. They didn't create their own certificate of ascertainment or white out the other names and put their own names in. Instead, they did what they believed they needed to do to preserve the ability to be the electors should they prevail on the federal level. They also rely on mailing records, which seems to be absurd. They didn't put on the return address that these came from the Secretary of State. They just sent them in to the agencies. Again, they rely on the Supreme Court ending the litigation, but they've never addressed the fact that, and they didn't provide information to the grand jury about the fact that the deadline to file a cert petition to the United States Supreme Court was over. And again, they never pretended they won the Nevada Supreme Court. They never pretended that they were the official electors of the state of Nevada. The state also relies on various email chains where it says that they're trying to comply with the details. And they argue that if it was merely an expression of their First Amendment right, then why would the details matter? I think this argument ignores there are two types of First Amendment activity here. One is the political theater that they engaged in at the ceremony. The second was preserving their rights. They were concerned that if on the federal level, if they prevailed, if somehow Trump were declared the winner of the election, that it would be a meaningless victory if they hadn't sent in the elector certificate form. They believed they had to send it in. Mr. Chesbrough had reached out to them, given them the language, and they used it. They wanted to do the best they could to follow the formalities. And again,
Excuse me, I'm sorry.
Go ahead.
Are you not kind of asking me to do a lot of fact finding that probably should go to the jury? I don't necessarily disagree with everything you're saying. I'm just not sure it's my job to make that decision.
Understood, but I'm not asking the court to make factual findings. The question today, well, I'm pointing out why the evidence that they came forward with doesn't at all support an inference of guilt. They don't have a heavy burden, but the evidence has to be weighted in favor of guilt.
Slight burden.
A slight burden, but it has to be weighted in favor of guilt. And they haven't presented anything that shows that that the defendants didn't believe that Donald Trump had won the 2020 election, or that they were trying to trick anyone. And just to give another example, and I think the fact that they rely on this evidence just shows that there's no actual evidence of fraud here at all. For example, they rely on the fact that there are emails in which they say, I'm hoping Ted Cruz and Rand Paul will maintain their outrage to the fraud in the election and will lead a senatorial pact to challenge the elector slates. The reliance on this evidence and the states related argument shows that they don't actually believe that the defendants were trying to trick anyone. What they really object to is the defendants even going to the federal government, even potentially preserving the ability to go to the United States Supreme Court, or advocating that the Senate should voice concerns about the results of the election. And that's exactly what they do. And excuse me, my watch went off. But they said, for example, they argue defendants intended that their documents mislead Vice President Pence by convincing him to not count Nevada's electoral college votes. That argument that they make shows that they're not arguing that Pence would have been confused, or that Senator Cruz would have been confused. They're not arguing that somehow somebody would have mixed up the defendant's certificate with the official results. They're not arguing that at all. What they're really arguing is that they believe that they can criminalize and punish, advocating that the Senate plays a role in the more than just counting the elections, that when they count the votes, that they can voice objections to the way that the elections were conducted in the states. They can't do that, Your Honor. This is not evidence of fraud. This is evidence the state is trying to punish defendants for arguing that Senators Cruz and Paul should object on the Senate floor. Can they do that? Yes. Are they wrong that those senators or Vice President Pence should have been able to do that? I think so. But are they entitled to be wrong? Are they entitled to make arguments? Are they entitled to petition the government? Are they entitled to argue to Ted Cruz and Rand Paul that they take action? And the answer to that is yes. All of this evidence shows that the state disagrees with them, that Trump won the election, and they want to punish them for challenging that. A criminal prosecution can't lie on the political theater of the ceremony or on the fact that they submitted a certificate because they wanted to preserve the ability. The evidence has to be weighted in favor of guilt and not just of the type that could inspire moral outrage among political opponents. The state's evidence just cements that this is nothing but an effort to punish things that the state cannot punish. If we look at the actual two charges at issue and the intent issues, we first look at NRS 239.330. And there, it requires that each defendant knowingly procures or offers any false or forged document. Again, these aren't false or forged documents. They had a legal argument that they believed they won the election, and they were asserting that legal argument in connection with a potential United States Supreme Court cert petition or arguments on the Senate floor. They are entitled to make those legal arguments. The state makes much of the fact that NRS 239.330 is a general intent crime, and the instructions to the grand jury included that the co-conspirators can be responsible for the probable and natural effects of the conspiracy, but it doesn't change the fact that the agreement has to be for an illicit purpose. And each co-conspirator must knowingly procure or offer any false or forged document. And there is no evidence that any of the defendants believed that their legal contention that they should be the electors for the state of Nevada was correct. They never, again, would we have a case here? They weren't. I agree with you. They did not know they weren't. They knew they weren't the official. There's a big difference, Your Honor, between believing that pretending that you're the official Nevada electors. They never pretended they were the official Nevada electors, Your Honor. They asserted that they believed that there were election fraud, irregularities, such that they should be instituted as the real electors by the federal government. In any case, Your Honor,
We are. They didn't say we should be, we're gonna be, we wanna be, we are.
that in the memorandum they said we are the electors from the state of Nevada. As we detailed on page 3 of their brief, that there is a huge difference between that, Your Honor, and asserting that they are the official electors from the state of Nevada. On their certificate, it didn't port to be an official state of Nevada document. It had authentic signatures. There was no effort to modify the original version. It wasn't sent by anybody other than Mr. McDonald and the Republican Party, as opposed to the state's documents that were sent by the Secretary of State. They didn't put, if you look at grand jury, if you compare Exhibit 4 and Exhibit 5 to the grand jury, they didn't put the state seal on their document. They believed that they had won the election. For example, Your Honor, I believe that Gore won in 2000. I believe he won the election in Florida. You can believe that the official results are wrong, and they believed the official results were wrong. They didn't pretend to be the authentic, real electors from the state of Nevada. They did not pretend to be the certified electors, and that's why they didn't include a certificate of ascertainment. They labeled their certificate of the vote of the 2020 electors from the state of Nevada. They didn't call it the state of Nevada certificate of the vote. It's very That's different language. They believe that they are.
Different, I don't know, if it's meaningfully different.
It's meaningfully different because they didn't pretend to be the official Nevada electors. The state's arguing that there's evidence of intent because they wanted Senators Cruz and Rand to take up the issues with irregularities in what they believe to be election fraud on the Senate floor. And that is evidence that they were trying to defraud people. There's no real argument that anybody didn't know they were not the official electors from the state of Nevada.
I think I've said that before. I come back to the impossibility of it all. I mean, I'm not sure how there could be an intent to defraud something that can't, I don't know, like an impossibility sort of
Well,
thing.
there can't be intent to defraud when you openly say, we know we lost. The state of Nevada says we lost. We disagree with the state of Nevada. We're doing this to preserve our ability to challenge that.
They didn't say that part, that would have made it a little bit easier for me.
They didn't say that on the certificate, but
And if they
they
had done that conditional language, that would have said it.
but during the ceremony that the very ceremony that the state relies on, in the political theater of it, to show that there was intent to defraud, in that ceremony they acknowledge that they lost in Nevada. And there's no real argument that they intended to defraud anybody. Again, that the vice president or Senators Paul and Cruz somehow didn't know that they were the real electors is just not reasonable. But again, going back to the actual statutes, 239.330, it requires that, and the Vaughn case makes that clear, and I think the state really underemphasizes what Vaughn holds. In Vaughn, they make clear, the Nevada Supreme Court makes clear, that the purpose of 239.330 is to prevent officials from acting on documents in mistaken belief of the accuracy. The documents under the statute must have the present ability to be filed under state or federal law. In Nevada, the Secretary of State oversees the electoral vote. The Secretary of State creates the certificate of ascertainment. This isn't like a deed where you go to the county office and you submit documents to be recorded, right? This is not something that citizens provide to their government. There's no issue here that the government could have acted in mistaken belief of the accuracy. Maybe, perhaps, if they had snuck into the Secretary of State's office and there was the possibility that the Secretary of State's office and the election staff would have forgotten who won the election and they tried to switch out the certificates, maybe we'd have something there. But they sent them to the Secretary of State. The Secretary of State didn't do anything about them. The evidence that we detailed makes very clear. Mr. Voloshin said these are not the type of documents that can be filed. Mr. Voloshin said that, literally said that in his letter returning those documents. That's what he wrote in his response to Mr. McDonald's mailer. He said, we're not doing anything with these because there's nothing under the law that can be done with these. The state's main guy under the Secretary of State overseeing elections, that's what he determined. There's nothing the state can do. The state can't point to any statute that allows the state to file these or take any action on electoral certificates from citizens because they don't. In Nevada, the Secretary of State oversees the elections and creates a certificate of ascertainment. The defendants did not create a certificate of ascertainment, and it is true, they also sent the certificate, the electoral certificate, without a certificate of ascertainment to the federal government. But the federal government, the testimony that we detail in our briefs, makes clear the federal government also, not just because Mark Voloshin called, but they knew that this was not the document that they would rely on as the official state of Nevada document. There was no law that let anybody act on a citizen's alternate certificate of electors. There is no law that they can point to. There is no law that they have pointed to. I think that Mr. Voloshin's letter back to them makes clear there's no law that would have allowed anybody to act on these. The Secretary of State oversees it. Where is the effort to defraud the Secretary of State, who knows who the electors are because she oversees the elector vote? Again, all they were doing was preserving their right. Did they not include special language that some states included, including in Pennsylvania, where there were lawyers involved? It's true that they didn't, but the question today isn't why they didn't do that. The question is there evidence here? And let's turn to the forgery charge, which is a property crime. And it's a totally circular argument for the state to claim it's false that they won the election in Nevada. It's false they won the election in 2020. And so because they had it and because they submitted it, that's forgery. And I think their reliance on the Supreme Court's cases ignore that the reality is that you have to have evidence and facts that support an inference of fraudulent intent. And there are very different facts in those cases that really do fit into the forgery property crime statute. In Patton, someone tried to purchase something, I think United Airlines flight, with a stolen money order with their own name added as payee and a forged signature of the maker. The Supreme Court didn't say, anytime the state says something is fraudulent or false, if you have it, you've committed this crime. They said that they relied on the Rampage case to support the fact that under those facts, there was sufficient evidence of fraudulent intent. In the Rampage case, it involved a stolen and forged check, and the court said that possession of a forged paper by an accused with a claim of title there to unexplained is insufficient. There is no forged paper here. There is no forged paper here. They didn't cross out any names and put anything on, and they're not trying. If Mr. McDonald and the other defendants had marched into the Secretary of State's office and said, "This is the real one. You must accept it." And we're now the real electors right now. We're the official ones. And if they had sent in a certificate of ascertainment and pretended to the federal government and to the media that they really won the election, we would have a very different case. But all they did is exactly what they said out loud. And I am not aware of any instance in which someone's committing fraud and forgery in which they say, hey, there's a weird thing, because if we end up prevailing and we didn't do this, then it'll be an empty victory. So what we're doing is we're sending this in so that we can preserve our rights. They make a big to-do about Mr. Law saying things like that he's disappointed in the legal process. When I lose in court, I'm disappointed too. People, you asked earlier, well, they didn't win. You're right, they didn't win. I believe they did not win. They disagreed. They believed that they had won and that the Nevada Supreme Court's decision was wrong. Their deadline to go to the United States Supreme Court was not up when they submitted their certificates, and the Senate had not convened on January 6th. There's just no actual evidence of fraudulent intent. It's too much to just say this is false because they disagreed with the state's official results, and therefore this is forgery. The only evidence they have of falsehood is that the state disagrees with them. They have no evidence that they didn't actually believe what they were saying in court papers and to the media, that they thought Donald Trump won, and they thought the government. They didn't say, I know there's a lot of emotion surrounding January 6th, but these defendants weren't saying, and so we're gonna go stage a coup. That is not what happened here. They said that we think senators should do something about this. Senators Rand Paul and Ted Cruz, they should do something about this. We think that the 12th Amendment allows them to do something about this. We want to preserve our right to go to the United States Supreme Court if we decide to do so. That's all the evidence they point to. That's all it shows. That's not evidence of intent. That's evidence of political disagreement, of a disagreement. And again, I think they're wrong too about their interpretations of the law and the United States Constitution. But Supreme Court justices and constitutional scholars disagree about this all the time. I think Lawrence Tribe was arguing that Trump shouldn't be able to have been elected last election. Does that make him a liar? I think he's wrong on the law. People are wrong about the law. All they did, and they did it publicly, which we don't have the burden to undermine intent. I'm not asking the court to make a factual determination. I'm pointing out that everything they point to is evidence of the opposite of intent to defraud. It shows that they were publicly saying, we think there was fraud. We think the Nevada Supreme Court got it wrong. We think that we want to take this to the courts. We're going to fight. They rely, for example, on Mr. McDonald saying, we're in this for the long haul. We're going to keep fighting because he's concerned about election fraud. They have pointed to no evidence showing that they didn't think the state of Nevada got it wrong. All the state of Nevada points to is the state of Nevada says they got it wrong. Their certificate of the votes, it's true. It did not have caveat language, but it was obviously not an effort to look like the real thing. And the fact that they submitted that is not evidence in and of itself of an effort to commit forgery or to have anybody act on those documents. They make much of the fact that, sure.
That's a better response to the forgery. But the 239330 doesn't have all that extra stuff. It's just a false submission that might be filed if genuine.
That might be filed and acted upon by the government. So that the problem they have there is that
It just says, if genuine, might be filed, registered, and recorded in the public office. There's no acted upon or it's real simple.
Understood. But what the Nevada Supreme Court has said about that is that the purpose is to prevent governmental reliance on documents that it can act on. That's how the Supreme Court interpreted it in the Vaughn case. And
I understand that.
so they must have the present ability to be filed under state or federal law. They didn't have the present ability to be filed under state or federal law. If you look at the Nevada election law, this isn't like I pointed out earlier, this isn't like a deed, Your Honor. This isn't something that the public goes and takes to the government and then the government files it and it becomes an official government record. That isn't how the certificate of the vote works. The certificate of the vote, the Secretary of State oversees it and creates all the documents. This isn't the type of thing that the public submits to the government that there's a concern about preventing officials from acting on the documents in the mistaken belief of accuracy. In the testimony of Ms. Vincent from the National Archives and the letter back from Mark Vlashin reinforces exactly that point. But there is no law that actually allows a Nevada citizen's certificate to be used as the real thing. That's just not the case. When you look at Nevada law, it's the Secretary of State that creates the official votes, the official documents documenting the elector vote. And they go to the federal government. And obviously, the Secretary of State isn't about to act or file something from a member of the public when the Secretary of State oversaw the election and she creates the certificate of ascertainment. So the idea that these are the types of documents that have the present ability to be filed under state of law, or that criminalizing this behavior furthers the purpose of preventing officials from acting on documents in mistaken belief of their accuracy is just not so. Additionally, that while they didn't prosecute the defendants for election law crimes, we pointed out that there are provisions that if they truly believed that there were election law violations here, and we pointed to the specific statutes in our briefing, they could have pursued a charge under the election law statute. And NRS 239.330 prohibits its application to conduct that could be punishable under the election law statute. Of course, we don't believe our clients violated the election law statute, but if what the state argues is so, they could have pursued a charge under the election law statutes. They chose not to, and then they said this wasn't a crime, and then finally on the eve of the statute of limitations, they convene a grand jury, and they struggle to find potential crimes that fit, and this whole prosecution is a resulting effort to fit a square peg in a round hole. These crimes just don't fit. Those documents didn't have the present ability to file. They didn't knowingly contain a false statement of the defendants, and they're not of the type that the government can act on reliance on, and nor did they. This also isn't forgery. If they didn't change and they didn't put anybody's signature on, and that is a specific intent here, crime. And the fact that they submitted it in and of itself can't possibly be a sufficient basis. It's not evidence weighed in favor of guilt. The elector's certificate in and of itself cannot be evidence of guilt. The state's argument, the state's position that even sending it in, I don't know, for example, if they had included the caveat language, if at the end of the day they had won, if that would have been a valid electoral certificate. We'll never know the answer to that question because, of course, they didn't win. They didn't win, and the Senate didn't return anything to the states as they had urged, right? As some people had urged. So we won't know. But what the state has never explained is how people can challenge election results if they truly believe there's fraud without running afoul of this type of prosecution. And in fact, all of the evidence that they point to shows that all they're trying to do is punish disagreement with the official election results. The stolen valor case shows that you can even lie, right? You can be wrong about something. You can pretend you're a vet when you're not a vet. But these defendants did not lie. There's no evidence that they lied. They said out loud, they said it over and over. They said in the emails that the state relies on. They believe that there were election irregularities, that there was election fraud in Nevada, and they were preserving their rights, and they were asking the federal government and preserving the right to have the federal government fix what they saw to be a problem. The idea that they couldn't do it after the safe harbor date because the state's position is that after that, that the state's decision about who won is dispositive, ignores that they could have gone to the Supreme Court. And I agree with their general position about how elections work. I'm more politically aligned with Attorney General Ford than I am with the defendants. I agree with their positions. But the question here is mere disagreement with the fact, with who won the election, is mere disagreement and petitioning the federal government, advocating that their right, not the state of Nevada, is mere disagreement with the federal government sufficient to infer intent under either of these statutes? The answer to that question is no. When Attorney General Ford first said that when he was going to the legislature that there was no statute that fit these, he knew there was no crime here. He knew that what defendants were doing was disagreeing with what the state of Nevada said. And under the Constitution, not only can we not infer intent from your disagreement, but such a criminal prosecution cannot stand.
Are we doing it in parts? You want to do you? Are you doing like kind of separate topics so that she can?
Yes.
Mr. Wright's handling the exculpatory evidence and chasing horse issue.
So do you want to respond first to the initial arguments?
I'll defer to the court,
I
whatever
don't
the court
care.
wants.
I mean, sometimes it's easier, it's fresher in my mind what she just said. and
Okay.
then-
All right, we'll go with the intent then.
Okay.
All right, thank you. Your Honor, I appreciate at the very beginning because I hate to sound like I'm stating, criminal law 101, but intent is a question of fact for the jury to decide. And this court said that specifically. It's not a role of this court to dispose of a case where there is sufficient evidence presented that identify the facts. And what Ms. McLetchie is asking you to do, and what she's doing is she's comparing her version of the facts that were presented and saying, believe my position. My position is what stands. That's not what this role is. If we're getting to the point where we're arguing whose version of the facts should be believed, that is right for the jury, not at this point.
Can I just ask you, what facts did she get wrong? We go to trial, you go to a jury.
Yeah.
What facts that she presented? Because I've said from the get-go, I don't know how you could have an intent to defraud because this was going nowhere.
Well,
It couldn't do anything but preserve. Nobody was gonna fall for it, nobody was gonna go, oh, we got this paper now, oh, I guess maybe, he didn't win. So let's act correct. I don't understand how there could ever, what gain do you make through fraud? How can you ever successfully do anything with this? And I've said that from day one. So that's my problem. I don't know what facts you're gonna give to this jury that say they intended to defraud. Defraud who? To what extent? To what end?
sure.
Nowhere. It's never going anywhere.
The question is not whether it's successful. I know, but that
But
is.
I'm asking you, in order to have an intent to defraud, you have to have a goal in mind. You're defrauding for some purpose, to steal property, to buy something with a stolen credit card, to do something. What were they intending to defraud to do?
They were intending to change the outcome of the election. And in their certificate, Ms. McLetchie got up.
And you're saying that on some level, this could have done that?
Well, when you look at what their intent is, right? When you read those statements that we outlined in the brief, where they say, let me go to it right here, I referenced it in part 7, where it says, the other possibility is that the House and the Senate could decide it's unclear who should have earned the Electoral College votes, and they could vote to give Nevada's vote to either candidate. If it happens in enough states that voted for Biden to reduce his electoral vote count below 270, then no candidate will have been elected by the Electoral College, and it is likely that Trump would win the vote in the House of Representatives and be elected president. This is coming directly from their mouths.
And
Their
you're saying
version of the certificate,
that their certificate could result in that?
yes, because
How
what
can
their
it be from A
position,
to B?
so they start by saying that they are the duly qualified electors for the state of Nevada. I think
But
there's-
everybody knows they're not.
that doesn't matter though. They are.
It does matter.
It
It does matter. If you give me a fraudulent credit card and you know it's fraudulent, I say it's fraudulent, and I give it to you to do anything, how can there be any intent to defraud? If I say, here's a credit card that doesn't work and it's stolen.
But if you pass it, that's your intent is for them to take it, to receive it, to review it. They're saying, you asked her, did they say they were duly qualified electors? The answer to that is yes.
Oh, I know they did. I
In
know
both
they-
documents, they
But
said that.
here's where I'm coming from. I mean, I think it's clear what they were doing. I just don't know where my rule fit. I think it's clear that there should have been conditional language in there. I think that kind of made the difference everywhere else. And I'm kind of thinking, but isn't it implicit in there? And even if it's not,
I think that
it's so obvious that they're not who they're saying they are, and they're not.
you can look at something and think, well, that was dumb. But that's not what the job is here. The question is, did they utter or did they offer a forged instrument? And the answer to that is yes, because the document itself, the certificate of vote, is a document that can be filed. Mark Voloshin and Miriam Vincent testified that these documents,
Can be filed if genuine.
meaning The actual certificate of vote, the genuine certificate of vote, is filed. It is filed with the Secretary of State's office. It's filed with the National Archives. It is filed in the U.S. District Court, and it is filed in the President's Senate. That genuine certificate of vote from all the states are permanent records that are filed. That is the question, the type of document. And so the certificate of votes here were forged and false because they declared themselves the duly qualified electors, and then they passed it.
My jury's still out on the forgery aspect of it, but clearly they're false.
Right, well, and forgery contains the false making. So this document is a false making. The entirety of the document was false. Therefore, it qualifies under forgery. And so when they passed it, and Your Honor, I want to point, the fact that we have safeguards to protect our elections, because you're talking about this impossibility aspect, the fact that the safeguards worked doesn't make the crime itself impossible. Their intent was for those documents to be considered.
I'm telling you right now, it was impossible. In this case, this was never going to result in anything, but
that's a question. That's a question for the jury, and I keep coming back. The fact that it wasn't successful doesn't make it any less criminal. And I want to point that when we're saying that they are representing themselves as duly qualified electors, they were trying to be Nevada's electors. They weren't trying to be
They were trying to be what things they were doing, but they certainly didn't think their filing that was going to make them so.
Well, I think that's just like that's a smoke screen for legitimacy, right? They're saying, oh, we had our rights to appeal to the court. That's just a smoke screen, because at the time when they made those statements, the litigation was done. There was no additional litigation that would have changed the fact that they were not the duly qualified electors at the time that they made those statements. And there's a lot of talk about what we're criminalizing.
There wasn't a potential to the Supreme Court?
That's a smokescreen, because the Electoral College Act.
Was there not?
There was not, because the Electoral College Act says the state court has determined and finalized. It's not potential appeals down the line. Has the state court determined who the winner of the election is? Has all election litigation contests been completed? And the answer to that was yes. It was ruled against them. They all knew it. Yet they got up there, and I want to point out, we're not criminalizing speech. The charges that we have charged them with very specifically allege criminal conduct occurred at the point that they uttered and offered their false or forged documents. They're entitled to speech. They're entitled to theater. They're even entitled to lie. None of us disagree on that. But they're not entitled to try to change the results of the Democratic election by reducing those lies to writing and passing them off as genuine certificate of votes for Nevada's presidential election. And that's what they did. They called themselves the duly qualified electors, and they sent them to all of these places. The theater ended at the point that they took them to the post office, they mailed them, and they were received. That is where the crime is. They wanted those documents to be received. And I'll come back to the intent argument. When we have to go back and forth about whose version of the facts are we to believe, that is where it is a question of fact for the jury. And Your Honor pointed that out at the very beginning, because the role of this court is there sufficient evidence for the jury to hear the state's position of the facts? The defense can get up and argue everything that they're arguing today through legitimate evidence, and then it's up for the jury. It's not this court's role to make that determination at this point. I know the court talked about, or Ms. McLetchie referenced the Vaughn case. I think they're misconstruing that holding. I think the question very clearly clarifies whether genuine documents filed and recorded. When you read the documents that were attempted to be filed in Vaughn, they were wholly made up documents that had that were not legitimate documents that would ever be filed in a court. That's not what we have here, as I said. The analysis falls on the category of document and whether a third party could rely on it, and the answer to that here is yes. Third parties could rely on it. They spent a lot of time talking about what Mark Voloshin thought, but those documents were mailed to 3 other parties. The one, the President of the Senate, who actually considers those documents. And he could have very easily challenged the real certificates with these other certificates and made a different outcome. I realize you think it's ridiculous, but that's what they wanted. That was their intent. They wanted that to happen.
They didn't have all their ducks in a row for it. They didn't file what they needed to file with, so that wasn't going to happen.
But it doesn't matter if they didn't have all of the requirements. The fact is that they tried. They intended for those documents. It doesn't matter that it wasn't successful. That's not the question. The question is, did they have an intent to defraud? Did they want those documents to be considered? And the answer is yes. It's very clearly yes when you look at all of the evidence.
I mean, obviously they wanted them considered. The question is, do they want them considered for a fraudulent purpose? And I still have yet to hear what fraudulent purpose. And I'm just not buying fraudulent purpose that somebody would actually take them as legit.
I think the fraudulent purpose is to change the outcome of the election. That's what the intent of all of this was. This wasn't just we disagree. They wanted very clearly for a different outcome to happen. And they wanted that so badly that they went through and they submitted forged documents, calling themselves the duly qualified electors to the state of Nevada. I think at this point, you don't have to agree with it personally, but that's not the role.
And I'm struggling because it is somewhat factual, but I also think, I don't think it fits. I think there's a reason that the Nevada legislature at one point passed the statute to create, making it a crime to create or serve in a false slate of presidential electors and conspired to do so. Granted, it was never put into law, but that was 2023. If this fit here, why did we need that?
Well, I guess I didn't point that out yet, and I appreciate you bringing that back up because 293 at the time didn't apply. The only thing, the statute that they cite to in section 293 is somewhat of a catch-all that if you violate the election laws, then you could be subject to a penalty. And the only thing that might apply is the faithful elector statute, but that specifically goes to the individuals who've been declared the duly qualified electors, which in this context would have been the Democratic electors. There's nothing in the election statute, specifically 293, that applies. That was what.
But if 239 and 205 are perfectly fine, what do we need something else for?
Because these crimes are D and C felonies, and the person who was sponsoring that bill felt that to try to overturn the outcome of the election, there should be a harsher penalty and to create a law that specifically addressed that. And that's what Attorney General Ford said when he testified. We're specifically talking about election statutes. It'd be great if there was one. There wasn't. That doesn't mean that the conduct here doesn't apply to the already existing laws. And it's our position that it does. It's our position that the evidence is sufficient to bind these over. And I'll point out that there's a lot about what they said in public. But what they say in private, in their emails, is very different. When they say we're out here trying to challenge it in court, privately, they're not actually doing that. They never file anything after the December 8th. That's the smokescreen. They want this persona, but then privately, that's not what happened. Because what their intent was to change the outcome of the election. Doesn't matter that it wasn't successful. That's not the question.
And I'm struggling to figure out how filing what they filed, false boards or otherwise, could ever change the outcome of the election. Other than political, I don't know what you want to call it, but drawing attention to it so that on some other avenue something might change. But the document itself, fail to see how that could ever impact the outcome of the election.
Well, and it doesn't have to be a really great forgery, right? It could still be forgery if it's really bad. It can still be forgery if it's missing parts of what would be in the genuine document. The question is if it's their intent for those documents to be considered and passed, then it's criminal. The crime is uttering and offering a false or forged instrument, right?
Right, but you gotta have the intent to defraud, so you have to really follow it all the way through. It's not just the uttering, it's, you gotta know what's gonna happen at the other end.
They have to know, they have to want it to happen. Not that it actually does happen. They have to want it to happen, and they did want that. That was their intent. And that is what the grand jury found. And that we have to come back to where we're at, a petition for pretrial writ. The grand jurors found that they had the requisite intent. Were there facts sufficient to support that? The answer is yes. They can disagree, that is their right, but that's what a jury trial is for. And I don't want to belabor and go through everything. I know this court's read everything, so.
I'm struggling, I'm back and forth, I could probably argue both your sides. And I'm.
But if you're going back and forth and arguing both sides, right, that's where there's questions of fact. That's where.
But like I said, I can go back to the arguing questions of fact on some level to me, grown adults with a modicum of intellect aren't filing this, they're thinking they're gonna impact the election. They're filing it to preserve or to draw attention to or make noise about, but not to impact the election. But I kind of back and forth, is that really my job? And then on the other hand, which will bring us kind of to, I think, where Mr. White is going to argue now in terms of some of the stuff that the grand jury didn't get. Because I will say I have some concerns about that, because in the overall, when you say the grand jury came back and they made a decision, I have some questions as to, did they have the full story when they looked at it? Because I have the benefit of everything, so my view may be slightly impacted by the fact that I know a lot more than they probably did. So you want to respond to her first?
Yeah, if I might make a few points, Your Honor, if that's okay. I know you want to Mr. Right up, but I'll be brief. I just wanted to make the point that you had brought up New Mexico and the Attorney General deciding not to pursue charges in light of the caveat language. I think the courts in both Michigan and Georgia threw out those criminal cases without that caveat language, so I just wanted to point that out. And the court's absolutely right that fact questions go to the jury. The state's burden isn't high, but the evidence, the state still has to meet its minimal burden. And if it's so obvious that there's no evidence of intent, it's not weighted in favor of guilt. Intent is an element of the crime. The state has to show slight or marginal evidence weighed in favor of guilt. The state has argued today that I'm making fact questions that really should go to the jury. No, I am pointing out that they were asked to come forward and delineate and point to all of the evidence that supported their claim, and none of that evidence supports any kind of requisite intent. They said they were intending to change the outcome of the election. That is true. Through the political process. The evidence they rely on is that they wanted Ted Cruz and Rand Paul to take this up at the Senate. They didn't try to do anything through trickery, and there's no evidence that they did. The one thing the state relies on at its core is that the defendants made the legal assertion that the state disagrees with and that the state's correct about, that they had won the election, that Trump had won the election. That in and of itself cannot be the basis of a prosecution and isn't sufficient evidence. And the state never explained how on earth you could challenge the results without sending in the certificate. The state argued, Well, there must have been intent to defraud because the litigation was done. The Electoral College Act means that the United States Supreme Court can't do anything. The safe harbor date is the date. That the state is making legal arguments. They legally disagree with the positions of the defendants. That cannot be evidence that the defendants were trying to defraud. It's evidence that the defendants had a different legal position than the state. And that's all it is. The defendants never, ever said that they were the official electors. Again, the state argued they were trying to change the outcome. Look at their private emails. Their private emails said, yeah, we need Rand Paul and Senator Cruz. We need them to take these election fraud issues seriously. We hope they keep the outrage up. Chesbrough, who was a lawyer, he stated that the certificates as he drafted complied with the law, even without the provisional language. The Senator Cruz, I think, went to Yale. The defendants aren't lawyers. The defendants are entitled to agree, to challenge through the political process. The Senate is still the political process. Now the state says the Senate wasn't the proper forum. That's a legal argument. That there are emails saying, oh, we want Ted Cruz and Rand Paul to keep up the outrage, and we want them to do something. And they cite the election fraud. The defendants believed there was election fraud. They believed that Donald Trump, in fact, won the election. And they say it's a smokescreen because they never actually filed a challenge to the United States Supreme Court. I think what they ignore is the fact that they had the right to preserve a challenge on the federal level. The fact that they didn't do so is irrelevant. The fact that the state disagrees and that the defendants agreed with the Ginsburg dissent in Gore v. Bush about what the actual date is and by which any election disputes need to be resolved is not evidence of intent. As for the Vaughn case, so the Vaughn case did not involve an instance in which there's a government official created document and then somebody, the Vaughn case involved a much more feasible scenario for criminal liability, and that's actually submitting something for being recorded. That is actually something people do all the time. The statute is designed to address the public submitting fake things for filing like deeds. So at least they had that there. We don't even have that here. The state of Nevada, the Secretary of State creates it, and they send it to the federal government. The state tried to distinguish the Vaughn case by saying, well, it was very clear that these were strange and made up documents. You know what Mark Velashan said about the certificate of the votes? They are bizarro documents. Mark Velashan said that we are returning these documents as they do not meet the statutory requirements for filing with our office. They're not of the type to be filed because they're nothing like what the public submits to the government to be filed, and they're obvious on the face that they're not the type of document that can be filed. The testimony from Ms. Vincent, we pointed it out in our briefs, I won't belabor it, but she made it very clear that she didn't act upon these because she couldn't have, because they didn't come from the state of Nevada. They didn't put the Secretary of State's return address on there. They didn't include the certificate of ascertainment. And as Ms. Vincent pointed out, they didn't have the state seal. The names didn't match the official certificate of ascertainment. There was nothing the federal government could have done. The people who received this, the state points to the Senate. They never wanted the Senate to get mixed up on the floor on January 6th and like, oops, we mixed up the documents and this is the official state of Nevada document. What did they want to do? Exactly what the state said they wanted the Senate to do. They wanted the Senate to keep up the outrage and voice objections, which they believed they could do under the Electoral College Act. Senator Cruz said he could do that they could speak out about irregularities that they thought happened in the election and return it to the states. Saying we want Senator Cruz to keep up the outrage shows that when they sent it to the Senate, there was never any intent, nor could there have been any intent to have these anyone be tricked because it was so obvious. Their credit card example, they said, well, if somebody submits a credit card, even if it's obviously a fake credit card, nobody here was trying to get anyone to accept a credit card. They didn't go to any government office and say, hey, I know you got some other documents from the state, but that's not the right one. They didn't go to Ms. Vincent and say that. They didn't say, oh, you need to switch those out. They were preserving their ability to have the Senate or the Supreme Court declare Trump the winner of the election. The court said it's just so obvious that they weren't the winners. They made it obvious that they didn't think they were the winners. They didn't include the certificate of ascertainment. They went on the recorded video. They said that they were trying to preserve their right. It is true that questions of fact go to the jury, but the state has to meet its minimal burden. And where it's so obvious that there's no crime here, it didn't meet its burden. There is no evidence of a crime. And the First Amendment also forbids the idea that the one thing they keep harping on, that they disagreed with the Supreme Court and they didn't agree with the official results, can't be criminalized. As citizens, we're allowed to be crazy. We're allowed to be wrong. We're allowed to say, we think that Trump won. We think that the voting system in Nevada has some irregularities. There's problems with undocumented people voting. They can imagine that there are way too many fake ballots sent in. They can think that. They are entitled to think that even if they're wrong. And that's a central problem with the state's case. They say the evidence of intent is the Nevada Supreme Court decided otherwise. So what? They were entitled to try to, as the state says, change the outcome of the election. They didn't want to do it through trickery. There's no evidence they wanted to do so through trickery. They wanted to do it through the political process, Your Honor. And the state hasn't submitted any evidence that they wanted to trick anyone.
Do you agree or disagree that in the event something had happened at the election had been flipped, that the defendants would have needed a preservation certificate of sorts? If it had been reversed and they hadn't filed something preserved?
I don't know that my opinion really matters, right, about what would have happened if it had changed.
Well, it matters to me.
Are you asking my personal opinion?
I'm asking what the state's position is. Mr. McLetchie argued that if they hadn't preserved and they had won and everything had been reversed, it would be an empty win because they hadn't filed the appropriate certificate in a timely manner and therefore would be stopped or prohibited from exercising them. And I'm asking if you agree or disagree with that.
Again,
Or if you
and
don't
I'm
know.
sorry for, I'm not trying to be difficult, but I don't think that analysis plays any factor in whether or not at the time that they offered and uttered those documents that they had an intent to defraud, because the fact is the law that existed at the time required that the state election litigation be completed by the safe harbor date, and
But
it
you're
was.
I understand both sides have different dates that they think come into play. I'm asking you if we all agreed on the same date and they hadn't filed this preservation and it got flipped, would they be precluded?
Yeah, I disagree that it was even a preservation, because that's not what they said. They didn't say the exact language of the contingency. That's all just smoke. That's all just a smoke screen for they're now after the fact saying this was what we wanted everybody. This is what our intent was really,
Well,
but that's not what it was at the time.
Trying to change the outcome of the election by filing and saying I won when I didn't.
That's what they did.
Honestly, I know, but it's, we know my position on that has been since the get-go. If that's all there is, I don't know that it's enough to get to the jury. So what I'm asking you, and if you don't know, that's okay too, do you believe that had they not filed something in a timely manner, had the results been reversed, would they be precluded from exercising their votes?
I mean, I think from a political legal argument, that's a debate that I think two different sides have. If you look at, the Gore case, there was clearly a dissent on all of that. I think had there been a change, like what happened in Hawaii in 1960, which that is not the same here because there was a recount going on, so the actual state hadn't certified, so it's not even analogous, but let's just say that it is. I think there would have been a mechanism that the government would have done to correct the outcome, right? If there was an actual legitimate issue.
But what I'm hearing you say is, you don't have a definitive answer. And so it makes it less unreasonable for them to believe that maybe this was something that had to be done. If you're saying it's open to a political debate, and I'm not really sure, maybe there'll be a mechanism down the road, then the other side of it is, if there's not a mechanism in the road right now, then what's the harm in filing this preservation?
Because it wasn't a preservation. That's not what the document said.
I understand.
So I think we have to, there's all of these, this is what, if we did this or if we did that, we have to look at exactly the conduct that happened. They took documents, they called them the certificate of votes for the state of Nevada. Then they said very publicly, I get that this is just speech at the time, we're the duly qualified electors for the state of Nevada, and now we're gonna cast our votes for Donald Trump and Pence. And then they do that, then they sign those documents that say you're the duly qualified electors for the state of Nevada. Then they take those documents and then they mail them. At the point in which they mail them, the political theater stops. The First Amendment doesn't protect criminal conduct, and they intended for those documents to be sent to all of those places to be considered. How they were going to be considered, it could have been an argument at the Senate, but they wanted those documents to be received. They called themselves the duly qualified electors.
Is not the equivalent of defrauded. When someone considers something, they're not necessarily being defrauded. Let me ask you this, if I take my team and we all were to create this certificate and say, okay, we are the duly elected electors and we vote blah, blah, blah. Completely garbage, completely made up, none of us are anything. And I mail it to everybody that's supposed to get mailed to. Is that criminal?
If it was your intent for those documents to be considered, and I don't want to say, well, what if this happened or what if that happened, because that's not the analysis here. But what would have happened if they did throw out Nevada's actual certificates, the ones that were sent from the Secretary of State, and then Nevada's electoral votes weren't counted? That's fraud. That's what their intent was. Because January 6th, you have to get 270 votes to be elected. What is that process? They take the certificates of votes from each state and they get up and they certify them, and then the president is elected. And what they wanted to do was have a different process happen on January 6th. They wanted Nevada's elector certificates to not be considered. They wanted theirs to be considered without any court ruling, because the court had been done. They didn't appeal anything.
The other ones were done, right? We had the official ones.
They were done. They were mailed.
So,
But they wanted those documents to be considered. The fact that they weren't isn't a factor, but the fraud is that it could have been.
and see, that's where you're losing me.
It could have been. They could have chosen. That's what they
I don't see
wanted.
how it possibly could have been.
Because
When you have the documents that are appropriately notarized or sealed or signed off on and everything else is all the way it's supposed to be, and then you get these kind of half-baked ones coming in, I don't see how this is ever gonna be a potential problem.
it didn't
And
happen
so-
because Michael Pence didn't allow it to happen. Because he considered the actual documents in the end.
As
That's
should have.
right.
And-
But the
and
fraud
to
was that
think that he would do otherwise is, in my opinion, ludicrous.
But that is not unfortunately that's not the consideration. It's what was their intent. Their intent was to have those documents be considered. That is the fraud. The fraud is to change the outcome of the election.
So
I know I'm repeating myself. I don't think I'm saying anything the court hasn't heard from me.
No, I know.
I don't know that
And
anything more I'm gonna say.
kind of back and forth.
Right, I think
because-
we've exhausted probably this argument. So.
Your Honor, the hypothetical that you gave, that's all the evidence they have here. is that type of scenario that someone sends in a certificate like that. And I think the state tells on itself when it says the intent was to have this considered on the Senate floor. They say political theater ends when you send them in, but they ignore that the First Amendment includes not just political theater, but the right to petition the government. They had a right to go to the United States Supreme Court, that lawyers might debate whether the United States Supreme Court could have forced the state of Nevada to do anything. That's not relevant. They had the right to petition the government. They got a letter from Chesbrough that detailed that these needed to be done to preserve the right to challenge the election. The state is arguing. They said, what if Pence had decided there were irregularities? What if Pence had accepted the Nevada certificate? That debate is essentially arguing that the defendants can't say to the United States Senate, we think that you and Vice President Pence, as the vice president, have the ability to correct the election fraud that we see in Nevada. They can. Are they wrong? Would that have been preposterous and extremely upsetting to me personally? Yes. But can the defendants argue that? Can the defendants advocate that the United States Supreme Court can take this up? Can the defendants argue that Ted Cruz, look, you've said that you can voice objections at the Supreme Court. Ted Cruz, we think that you should keep that. We think that you should keep that ire up because it really is election fraud in Nevada. They try to point to these private emails. All they have is the type of hypothetical that you have. They say, well, look at these private emails. They talk about Senator Cruz. They wanted Senator Cruz to voice objections on the Senate floor. That's called petitioning the government. And if the Senate had said, we're going to send this back to the state of Nevada, they believed there's no evidence that they wanted to do anything other than preserve the right. If that got returned to the state can't answer you about whether, if there were some subsequent decision that there was election fraud in Nevada and that Trump actually won. The state can't answer you if there would have been any remedy available if they hadn't preserved their rights. They need evidence weighed in favor of guilt. All they have is the hypothetical. All these private emails that they say show anything bad, the state tells on itself today because they argue that it should be illegal to advocate that Vice President Pence or the Senate should have done something about election fraud in Nevada. Constitutional scholars, Supreme Court justices, litigants, lawyers, we fight about things all the time. Are some positions preposterous? Sure, that doesn't mean we decide, well, it's not reasonable to argue that the Senate could have changed the outcome. They were entitled to try to change the outcome. There's no evidence that they were trying to change the outcome with a fake certificate. And there's absolutely no evidence that they did anything other than engage in the political process. And everything the state says today about what they think is criminal is just evidence that this prosecution would violate the First Amendment.
My only response is they do not have a right to petition by means of fraud. And in our position, and what the facts allege, and what the grand jurors found, is that they uttered and offered forged documents for filing. There are sufficient facts, and my request is that the court bind it over, because that is, the state has met its burden.
You know,
A 2-minute break, anybody? One more?
I'm good.
you know, the answer to your question that I don't think the state answered was the filing on the 14th, the reservation, was that required? If they would read the proffer of Mr. Chesbrough, who wrote the documents and told them what to do, whether he is right or wrong, he told the state that in order to challenge, if there is litigation going on in the 6 contested states, they all need to file and send in their reservation documents on the 14th Because if they don't, even if they win the litigation and they have not sent them in, they can't, his words were they can't flip the vote. All they could do was knock out the other votes, but they couldn't make their votes count. And of course, they didn't present that to the grand jury. And that's what I want to talk about. I have the same, Your Honor said, I know a lot about this, and I may know more than the grand jury knew. And I have the same problem when I know so much about this from reading the proffer, from having an actual preliminary hearing in this case up north. I had to go back and read what Chesbro said at the grand jury and compare it to what his truthful proffer was and figure out what they left out and the false picture they presented for the grand jury. And the false picture that was presented was that litigation had ended in Nevada, could not go forward, and if there was no litigation pending or that could go forward, there was no purpose in doing what these electors did. That's exactly how it was left with the grand jury, and all of that is false when compared to the proffer given by Mr. Chesbro that they did not admit. They let him paint a false picture. And it came at a crucial time. These were questions by the grand jurors after he testified. 2 grand jurors asked, what's the significance of whether or not litigation was pending? And it ends up, the grand jurors didn't ask real articulate questions. So the prosecutor said, I'm going to try to rephrase it a little bit. I'm in volume 2, page 44. Mr. Chesbro, pardon?
Will you just read it to me so I don't have to find it?
Yes. Mr. Chesbro, this is the prosecutor. I'm going to try to rephrase your question a little bit, talking to the grand juror. Mr. Chesbro, did you see pending litigation as critical to your theories here? Yes. Question, is it fair to say that your view was if there was no litigation pending, then there was no way to reverse the result, and therefore there was no way that these alternate votes would become meaningful or be counted correctly? Yes, because if on December 14th, all the lawsuits are over and the governor has said Biden won, and there's nothing more that's going to happen in court, then it's over. So there's no reason to file the paperwork. Now, that ends his testimony, essentially. What they didn't ask Mr. Chesbro, for obvious reasons, was the litigation over in Nevada? In the proffer, he explained that he didn't know whether Nevada was going to file for cert or not, okay? He also explained that they did the same thing in Wisconsin, that they lost prior to the 14th. He had them file the same documents, even though they had lost in the Wisconsin Supreme Court. Because under his theory, you had to do that in case you proceeded and won on litigation. And in Wisconsin, just In Wisconsin, he testified, or in the proffer, he said that on the 22nd of December, it was decided to go ahead with a cert petition, and he, Mr. Chesbro, filed it on the 29th. In Nevada, what does it mean that litigation is still pending? They had lost in the Supreme Court. They had 90 days until March 8th to petition for certiorari. Mr. Chesbro would have explained that. Nevada was one of the 6 contested states where there was ongoing litigation. And that's why it was Mr. Chesbro who reached out to these 6 folks. They didn't reach out to him. They didn't dream this up. This was Mr. Chesbro's first contact with them out of the blue. I am Mr. David Chesbro, counsel for Trump campaign, and the president wants you and the 6 contested states to file your alternative ballots on the 14th in order to preserve it because of the ongoing litigation. That's what these 6 non-lawyer people knew, and they received it. And then ultimately they acted on it. Now,
Was that presented to the grand jury?
Pardon?
Was that presented to the grand jury?
I believe it was. Yes. I mean, that was one of the first email. What wasn't presented to the grand jury was that the fact that litigation, Mr. Chesbro would have said litigation was ongoing in Nevada the same way it was in Wisconsin. I mean, it paralleled the same thing. But he did not know, because he hadn't spoken with counsel for Nevada, Mr. Banal, or any of these 6 people about, are you going for cert or not going for cert? But what he did say, which was not presented to the grand jury, and which we didn't have, and which is in our, we filed a reply to the writ attaching documents that were exculpatory that weren't presented to the grand jury. And what he did say, this is a December 11th, it's Exhibit A in our writ reply, which was filed May 15th, 24. So on December 11th, 2020, this is an email from Chesbro to Joshua Findley, higher ups in the Trump legal structure. At 9:01 today, Jim DeGraffenreid of Nevada emailed me asking Jesse Banal, by way of copying him, to update me on the Nevada litigation. Jesse Banal was the attorney handling it. However, it seems plausible for Nevada to seek cert in the Supreme Court on the same basis on which Jack Willencheck plans to seek cert from the Arizona Supreme Court dismissal. The courts rushed to judgment to meet the safe harbor date, which is a denial of due process for no legitimate reason, because the safe harbor date is irrelevant in a situation like this, and also because the Electoral Count Act in which it is contained is unconstitutional. The Nevada party struck the due process theme in its statement on the decision. This was not presented to the grand jury. His explanations about this in the proffer was not presented, but in his mind, there was a plausible continuation of litigation in Nevada, and that's why he sent them the documents and told them they need to do this. The The other exhibit we attached to our reply brief, Exhibit B, which is exculpatory, which we didn't have, which absolutely contradicts the testimony they elicited at the grand jury. This is an email on December 8th, 2020. Kenneth Chesbro to Judge Trupus. Judge Trupus was the lead attorney. He wasn't, they call him Judge Trupus. He's an attorney in Wisconsin who was leading the litigation in Wisconsin. And Mr. Chesbro had written the original memo, I think we call it, it's in evidence in the grand jury, the November 19 memo, which said litigation needs to be in existence in the 6 states going forward when we vote on the 14th. And then this later email says, this is to Trupus, I'm glad you pressed me, number one, in bold print, court challenges pending on January 6th, really not necessary. In my memo, I mentioned that a key element of the strategy I've sketched would depend on litigation, either in state or federal court, pending in the 6 contested states on January 6th. I'm glad you pressed me on that. On reflection, I think having the electors send in alternate slates of votes on December 14 can pay huge dividends, even if there is no litigation pending on January 6th. We did not have this. The state did. And of course, he said the same thing in his proffer, yet it absolutely contradicts where it was left at the grand jury. And of course, they didn't ask him, is litigation pending? Because they knew these answers would come out. Instead, they called in Ted Groves, an AG investigator, who testified that, and Mr. Woloshyn, both testified at the grand jury that the litigation was conclusively closed in Nevada contest by the December 8th Supreme Court decision. So you take what Mr. Chesbro told the grand jury, that if there's no litigation, there's no good reason to do this. And then they use the other 2 witnesses to close the door on it. And of course, they were then relying at the grand jury on the Patton v. Sheriff presumption. That's the instruction that was given to the grand jury in Exhibit 2. If you submit a fraudulent document, if I know it's fraudulent and I submit it for the purposes of probable cause, you can infer a permissible inference. That's Sheriff versus Patton. And of course, that's if it's unexplained. In this case, actually, they rely on the presumption, the permissive presumption, when they have themselves the evidence which rebuts or replaces. They had the evidence of an innocent. Your Honor said, I don't see a fraudulent purpose. Well, there was evidence of a non-fraudulent purpose, and it was the emails and the testimony of Mr. Chesbro, which was not given to the grand jury. He also answered, and it wasn't given to the grand jury, that in his opinion, the documents signed on the 14th in all 6 contested states, including Nevada, were not false or fraudulent statements. And his explanation for that is that and this is on page 39 of Exhibit I, Part 2 of the transcripts. He said, that's not a false statement, that's a performative statement. And he explained to the grand jury, to the prosecutors and the proffer, not to the grand jury. He said a performative statement is like when you write a will. I give and bequeath all of my wealth to the YMCA. That only becomes valid upon, as he explained it, upon the performance of a condition. And these were conditional documents that would become valid only on January 6th. And as he explained, just like in Hawaii, there would be one set of documents and another set of documents. And on January 6th, one or the other would be right. And whichever one was not right is void. He said that's what a performative statement and document is, and that's all these documents were. That was why he wouldn't even agree that these were false statements or forged documents. None of that was presented to the grand jury. Also not presented to the grand jury was what happened, why no conditional language in Nevada. He didn't testify in the grand jury as to why not. He simply said at the grand jury, he testified that in Pennsylvania, the electors were concerned about signing the document, which was the same as Nevada's, which he had written and sent everywhere. He said because they had a very political attorney general and they were afraid they might get prosecuted for a false statement. He answered, I guess I could see how a layman might think something like that and not realize that these are, to him, these were obviously performative documents, performative speech, as he said it. So he said, we'll rewrite it conditional for Pennsylvania. And he did and sent it to them. And he then said to Mr. Roman and Justin Clark and people above him, lawyers in the Trump campaign, why don't we do this for all of the states? Just so there's no issue, to make plain what we're doing. And they said no. He testifies that he asked 3 different times to do that. And in the meantime, 6 states became 7. New Mexico was contested. So he did the documents for New Mexico and he put conditional language in it. And when he did, he asked them for the 3rd time, wouldn't it be wise to tell the other states, let me change them? And the answer he got back from Mr. Roman was, F these guys, quote, was the answer. And in the proffer, they said, what's this? They said, he believed it was like on the eve, 12th or 13th, and it was going to be on the 14th. They didn't want to fool with it. And so he did not change it for Nevada. He also says he didn't talk to anybody in Nevada about this or tell them that there was any issue about this. So that's how it ended up. We had proposed, and the state we gave them the instruction, which the grand jury received, that if there's a specific intent crime and it shows that there was an accidental or innocent purpose behind it, then it's not an offense, okay? Our only problem was the grand jury didn't get the ammunition needed to implement that. If the grand jury had a clear picture of this material evidence, and it's material under chasing horse, and in fact on chasing horse, I know you've heard this and I've heard it, but it bears repeating. A grand jury is charged with the solemn duty of deciding whether the state has sufficient evidence demonstrating probable cause to issue an indictment. In fulfilling that duty, the grand jury checks the power of the state and protects fellow citizens from unfounded prosecutions. Our criminal justice system relies on the integrity of grand jury proceedings. Prosecutors have the privilege of attending grand jury proceedings, but this privilege comes with responsibilities. Nevada law requires the state to present exculpatory evidence. In this quasi-judicial function, the prosecutor acts as the grand jury's primary legal advisor. Grand jurors must be given information that is material to their determination. What could be more material to the determination about what was in the mind of these 6 people when they did this, other than the testimony and exhibits, pardon me, not the testimony, the proffer and exhibits that were excluded from the grand jury. It painted the true picture of why there was not a fraudulent purpose in what they did. Yet none of that was presented to the grand jury. The state answers, it's not your job to second guess the grand jurors. What's your job is to look at the information that the state had and knew they had and determine if it is material to the determination of fraudulent intent and whether the document was fraudulent or forged. I can't conceive of how it isn't material. And then your job is to determine whether that was prejudicial or not. And as I said in Crazy Horse, the state simply stated the state's omission prejudiced Crazy Horse. And our position here is even the evidence before the grand jury doesn't amount to probable cause, as we've argued over and over. But if you brought in the true evidence, which they did not, you would say these 6 defendants were prejudiced. The likelihood that the omitted evidence will be introduced at trial does not obviate the prejudice. And as the prosecutor was the only party present at the grand jury proceedings, we cannot sanction the state abusing the process and then benefiting from its own impropriety. That's where we end up here. Never did the grand jury get the correct picture or the correct state of mind of Mr. Chesbro. And the state answered under its in its latest brief with that a third party's state of mind is irrelevant to the state of the mind of the defendants. So it was not material to any element of the offense. Well, that third party is a co-conspirator. He was in the first draft of the indictment before he was immunized and cooperated. And in the indictment, it is alleged as the vehicle of criminality, aiding and abetting directly or as conspirators, and conspirator instructions were given to the grand jury. And Mr. Chesbro, the architect, the moving force, the one who came up with this and directed everyone how to do it, his state of mind was that he was committing no offense whatsoever and was doing what was constitutionally required. And then none of that was presented to the grand jury. So on that basis alone, the case should be dismissed or the writ granted. Thank you.
So Your Honor, thank you. I laid out in my brief my position on what Chasing Horse is interpreting and how that applies to Chesbro's statements. But I think what's really, really important is all of the evidence that Mr. Wright is referencing is Mr. Chesbro said this. Mr. Chesbro thought that. Mr. Chesbro spoke to people in the Trump campaign. Nowhere does he say that Mr. Chesbro had these conversations with the defendants and there's some writing that we then failed to present to the grand jury. In other words, that the defendants heard these statements and then that would have affected their intent. The question is, did the grand jury receive proper evidence regarding the defendant's state of mind? Mr. Chesbro's state of mind doesn't transfer to the defendants. In fact, when we're talking about, is there still election litigation pending? The fact is that at the time, the evidence that was presented properly to the grand jury was that it was concluded, but there were statements from the defendants plural, that they were trying to continue to challenge this. And that was presented to the grand jury. The grand jury heard exactly what the defendant's state of mind was. They didn't believe them because they obviously, returned the indictment, but they heard those statements. The fact that questions about Mr. Chesbro's thought process, his legal conclusions, which presenting legal conclusions to the grand jury is also improper.
Well, but it wouldn't have been presenting them as legal conclusions or the law, but rather the impact on the people he was working with, representing, advising, whatever.
Right, but
that would be the import of what he believed. Is he's counseling these folks, and if he believes it's okay, then there's no reason that they're not going to think it's okay as well.
So I think there's two
We
things.
generally expect our lawyers to advise us.
He wasn't their lawyer.
behavior. Well, you know what I'm saying.
No, I understand that. There's two things. Mr. Chesbro was not the 6 defendants' attorneys. He said that very clearly. He is not their attorneys. He works for the Trump campaign. So the question is, did those statements, did the statements that Mr. Chesbro say get relayed to the defendants such that they acted on that? No. There's no communications. The only communications that happened between Mr. Chesbro are those couple of emails that were presented to the grand jury. And Mr. Chesbro said those were the only communications. He never had phone calls with them. He didn't have any other follow-up emails. Everything that was, any communication that was presented between the electors and Mr. Chesbro was presented to the grand jury. Everything that Mr. Wright is saying is exculpatory is statements that Mr. Chesbro made to other people. And that doesn't go to intent. That doesn't go to a material element. And that is credibility. And that could be inconsistent, if you want to call it that. And what Chasing Horse is doing is it's saying material statements have to be, statements that go to a material element of a crime has to be presented to the grand jury. Now, sometimes those statements may also be inconsistent. And so it can be inconsistent and material. And in this context of Chasing Horse, It was the victim of a sexual assault, where this victim made a statement that was inconsistent than what she testified to at grand jury. And the court said that that was material to the element of consent, and because it went to consent, it should have been presented. That's not the same here. His inconsistent statements are not material to the element, and therefore they are questions, credibility is a question that should be presented to the jury. And I believe they specifically said, prior inconsistent statements of a witness does not explain away a charge within the meaning of exculpatory evidence. That comes from the Lay decision. In elaborating, the court said a criminal defendant is certainly entitled to impeach a witness's credibility and testimony at trial based upon prior consistencies. The simple fact that a witness contradicted himself in the past does not tend to explain away the charge and therefore make the witness's first statement exculpatory.
But it depends on what the contradiction is, right?
Well, it has to go to a
If
material
he's
element.
saying today there's no intent to defraud, and tomorrow he says there's intent to defraud, we're talking about two different, they are both inconsistent and material, right?
Right, but the question isn't did Chesbrough, what Chesbrough's state of mind was, or what his feelings were on intent. The thing is he presented them certificates and said, here's draft certificates. And then they said, great. And then they never questioned it after that. They edited their documents, they signed them, they sent them in. There was no questions about whether or not their conduct was criminal, or at least that's what the evidence was presented, because that's what we know. What we know is that they executed these documents and then they mailed them in. There was no other conversations with Mr. Chesbrough. Mr. Chesbrough said that. These were my only communications with the Nevada electors. That's what he said. So any statements that he might have said to other people don't factor in, not exculpatory. They can bring it up at trial, but it shouldn't be the basis to dismiss an indictment at this stage. And I don't know if the court has any, I don't want to just talk to talk. I'd rather.
Appreciate that. Now, well, I told you that this is close for me.
Understood.
It's close. I don't think this is what the statutes were designed for. I'm not sure that they can't be shoved in there, but I don't know why I'm shoving something in somewhere. And one of the things I'll probably go back and reread is the grand jury presentment, the proffer, because I think that there's, like I told you, I know everything, and so if I'm on your jury, I don't think you have it. Not my job.
Right.
But when I see everything, by the same token, I have to go see what they saw, and because it's a close one, to the extent that there may have been some things that could have been brought to the grand jury that might have made me feel more comfortable if they had a chance to look at everything and were coming back with an informed decision, but I need to go and look at that because I can't, at this moment, separate what I know. What I know is clearly, in my opinion, there's no sufficient evidence of intent to defraud. I don't think there was ever a potential to defraud. I don't think there was an end game to defraud. I think there was a lot of other stuff going on. I'm not saying it's good or bad. I'm just saying criminally intent to defraud. I'm not seeing it here, but
Well, and I'm sorry, I don't mean to interrupt. When the court goes back to make that consideration, at least with respect to the exculpatory evidence, remember, you're a career prosecutor, so you know this, we don't have to present every single piece of evidence at the grand jury or make all inferences in their favor. So the question is really, was this material to an element of a crime? And that is where their argument fails. So I just want to clarify
I
that.
get it,
because-
and yes, I was a prosecutor, but now I'm a judge.
Understood.
And so I'm looking differently, and I think what's exculpatory in a case that I believe is so close might have a lower materiality component, if you will. I mean, if two things are pretty close and something is just a little bit, it might go the other way, it might have more import in not.
Right.
In
And
a
I
run-of-the-mill
understand
case, I don't disagree with you, but in a case like this where there's so many nuances and it's so hyper, I can't even imagine how the grand jury, there's so much going on here.
And I understand that, and I think when we're talking about like the elements of intent, which this court keeps coming back to, they heard specifically from the mouths of the defendants because that video was played. They watched that video, they read those statements. So I think that they heard what from them specifically, and they still came back with this decision to uphold the indictment. So, you know, when we're talking about all of the exculpatory
I'll watch that
evidence.
too.
Huh?
I'll watch that, I mean, I'll look at the entirety of it, the transcript of the evidence there, and again, try to, because the First Amendment's kind of a big deal. So I want to be sure I respect that as well.
I don't disagree, it's not a big deal. I think it's a very important deal, right, especially in this day and age, but
And I fail to see how them doing what they did would ever have any impact on anything fraud-wise. I keep trying, but I can't get there.
I think I've stated my position.
You know, we've done this like
Yeah.
6 times now.
So I will leave it at that, unless the court has additional questions for me.
There's no question in the first emails they were sent, the Nevada 6, that it was laid out because it was a group email to all 6 states. Part of it was Nevada, and it was telling them, you are doing this because you may win the litigation. And in order to preserve your rights in the event you win, this is what you have to
Was
do.
that received by your clients?
Pardon?
Was that received by your clients?
Yes, that's the email that sent them, and it sent them all of the packets for their ceremony. It was the same email to all the states, and it wasn't any secret as to what they were doing. They were
The
doing,
grand jury had that?
did they have that? Yes,
And so that's the other side of it, is that they.
but the grand jury was then told that there was no litigation pending in Nevada, and without litigation, there was no reason to do it. And that was the false, and I don't know how that's not material. That goes to, was there an innocent purpose in doing this, or was there a fraudulent intent?
But I'm still not sure even if so, because
What?
I'm still not seeing the fraudulent intent even aside from everything
Right.
else because of what I said before.
Oh, I forgot. They didn't show all of the video, because the parts they left out, Jesse Law saying, we want to pull this right back into the courts. That they omitted, left out of the tape shown to the grand jury. They also didn't have Sean Meehan saying, we're preserving our right while there's ongoing litigation. That was not presented to the grand jury.
That's a bigger deal, no?
Well, they're misconstruing, there's 2 different videos. There's an edited and an unedited version. The edited version is what was presented in its entirety. There's an unedited version that has a camera laying at the ground for 15 minutes and then coming up. So it's not accurate.
But are
that-
those 2 statements recorded and not presented to the grand jury?
Those two statements were on the unedited version, but to the extent that they speak, there were statements about bringing it back into the litigation or bringing it back into the courts. That was in the edited version. McDonald referenced it. There's emails that were, or articles presented to a Wall Street Journal article that quotes Mr. DeGraffenreid that says, you know, we're trying to get this back into the court. So to the extent that they're all speaking for each other and what their intent is, that evidence was presented. So
It was
it's
not.
cumulative.
Sean, we presented that article with our Markham notice, asking it to be produced, and you did not produce it. The Jesse Law statement, we want to pull this right back into the courts. At 1 hour, 9 minutes of the long bright side was not presented to the grand jury.
I'm not disagreeing, Rick, that I'm saying that there was exhibits within the grand jury that had the Wall Street article that talked about Jim DeGraffenreid saying we're trying to bring this back into the courts. Mr. McDonald's arguments about bringing it back into the courts was presented. Jesse Law's statements about he wasn't happy with the court process. What I'm saying is there were additional statements not presented, but to the extent that what their intent was to put it back into the courts, that evidence was presented to the grand jury.
This much, not that much.
The judge is gonna look at it all. She said so herself. We're not required to present every evidence, like I said, cumulative
No,
evidence.
but I also think there's a difference when you've got 6 defendants. And so if you have more people saying things, it's arguably more. I'll look at it. Anything else?
Nothing from this. I assume the court's taking it under advisement. Do we have an idea of timeline as to issuing a decision?
No, I'm gonna call you back in because, in case I have questions. And wherever it goes, I prefer the winner takes control of that. If there's a lot and we're going to have back-to-back civil trials coming up here, so I'm gonna need some time.
Does this,
This is the exhibit of the Wall Street Journal article that was not raised.
she'll look at the record.
If it's in the record, I can look at it. If
It's
not
part
in
of
the
it.
record,
I
can't.
can't remember
So-
if it's exhibit 29 or exhibit 30, but there's a clip, an email exchange that says, here's all the documents. And then somebody, actually, I misspoke because he sent it to Chesbrough, and Chesbrough said, I saw your comment in the Wall Street Journal. And then they comment about, oh, usually quotes in the Wall Street Journal doesn't do any good, but this is, you know, and it has a clip of the article where it says what he said.
So, how much of what defense sent the state to present the grand jury was presented and how much was not?
Everything that I could present legally, I did, that I had authentic, in other words, anything that I could legally present, I did. So they sent me emails to present to the grand jury. If I were able to locate those emails with the proper certificate, custodian of records affidavit that authenticated the email, I found the companion email through our filter team, and I said, here are these emails they want us to present. Can you find them within this production so that I can present it to the grand jury? I did that. There's I think 3 or 4 exhibits that were specifically emails that were presented that they asked us to, and we presented those to the grand jury. They wanted me to present an affidavit of counsel. I don't know how that is proper evidence to be presented, but they had a declaration of counsel that they wanted me to present. That wasn't legal. I mean, there was evidence. I had to make a determination. But anything that I could legally present, I did. They asked me to present the instruction regarding intent. I put that in.
I don't remember.
I can't authenticate, and the last thing I'll say is I can't authenticate a Wall Street Journal article, but to the extent that the comments by the defendants were part of an exhibit that was authenticated, that was an exhibit to an email, That was presented.
I don't recall presenting an affidavit to counsel and asking it to be produced. Brian Hardy sent the Markham letter, and in it asked them to, it cited Supreme Court rule, whatever it is. They didn't produce that, but there was 90 days to file a cert petition after the 8th. That was not presented. If that's what you're talking about, his letter, we asked that the Supreme Court rule be presented and this grand jury be told and know that you could file a petition for cert. And instead, Mr. Groves and Woloshyn said there was no avenue for further review.
The question was that the election litigation was concluded at the time because by law, the state had to conclude its election by December 8th. And that's what happened.
But if there is a window in which litigation could be ongoing, and it brings us back to if some cert had been granted and if it had been reversed, would they be
I think that's just an argument they're saying now, years after the fact. That's just a smokescreen, because they never did. They didn't, and it doesn't matter, they never filed anything.
I know, but the other side of it is, if there's even a potential that you're gonna be left in the lurch, what's the downside? First of all, they do the theatrics of it, which they obviously wanted to do. But even beyond that, there's really no downside to a preservation of a document that goes in just in case.
But it's not you can't preserve the record by fraud, and that there's a difference. There is a difference. The First Amendment doesn't protect fraud.
I get it. But I'm also kind of leaning into the performative, that it's not said so much as fraudulent, but more as statement of intent if they get the chance kind of thing. I don't know. I've told you since the very beginning of this, I'm having a hard time with the intent to fraud because it's so impossible to.
Well, and I know we talk a lot about intent to fraud, but that is the requirement of one of the counts, right? And so there's a difference between the offering and the uttering.
Yeah, and then the other one, I'm getting a little hung up on the word genuine, because it clearly wasn't genuine, so does that even matter? I mean, if it's such a joke, if you will, that when they send it in, they're kind of laughing at it, of course, that brings us back to it, like, whatever I write and file, that could be criminal?
The genuine version of it could be filed. That's the only consideration. And the fact is that, yes, Mark Woloshyn and his team prepares those documents, but Miriam Vincent doesn't prepare it, Michael Pence doesn't prepare it, the clerk of the U.S. District Court doesn't prepare that document. And so there are other people outside of the preparer, as you will, that review and assess those documents. But that, again, that's not what Vaughn's saying. The genuine version of that document, if filed. And so the genuine version of the certificate of vote is a filed and recorded document. That's where it's the category, not whether or not they believe the quality of it.
Your Honor, in the Vaughn case, it was the quality and the obvious problems with the document, and there was a law that allowed the filing of something from the public. In that case, they can't point to that here. These documents couldn't be filed by the Secretary of State because she created them. They point to the federal government. Ms. Vincent testified that she didn't do anything with these except put them in a regular old, pile of paper because they weren't the official documents from the state of Nevada. These are official documents created by the government. The statute's designed to prevent government agencies from acting on false documents presented to them of the type that the public presents to the government for filing, like deeds. It's not this case. It's the square peg in the round hole problem. Finally, I just want to point out, because the state has said this over and over, that was just a smokescreen. This was just a smokescreen. They haven't pointed to what's behind the smokescreen. They haven't come forward with any sufficient evidence of an actual intent to trick anyone. It is not there.
The last word?
Love the last word. No, if we're just talking about Vaughn, I mean, these were the type of documents: eminent domain cover letter, notification of the Aboriginal Indigenous writ of possession and execution. It's a completely made up document. There's no mechanism or that document exists. It's not a certificate of title.
Let me, as a practical matter, if this document had been filed, what impact would it have? What would be the ramifications that we'd be worried about?
Well, they were accepted and received by all of these places.
Filed or whatever. How would they be practically acted upon that would impact anybody?
They were the actual votes. They were trying to replace the actual votes for the state of Nevada. That determined the electoral college vote.
How filing this false document achieve that end?
Because how I've stated specifically is that on January 6th, the electoral college votes and those certificates of votes are considered, and those become the results of our election. And so they're calling themselves a duly qualified electors so that their votes can be considered. Those votes can be challenged. That is fraud, because they were not the duly qualified electors. They didn't go and protest and say all of that. They executed fraudulent documents.
So are you saying that there's kind of an overlap between the false filing and the forgery counts?
And such that in their actions?
I'm taking out the forgery and the intent to defraud. I'm just the false filing to keep it cleaner. And
Right.
But I'm
I see
asking,
what you're saying.
what is the danger in that?
Well,
If it's
offering.
filed, what happens?
Yeah, I mean, like if we're talking about the offering a false instrument for filing or reporting, it's that Pence would consider those votes. He offered them and would consider those votes over the Democratic votes. That's the effect of the crime.
Because he wouldn't know the results of the election.
It doesn't even matter. I don't think that's the point. Is that they were
Couldn't
trying to have it
written a
changed.
letter? Couldn't they have just written a letter and say, you know,
That might be a perfect example of exercising their First Amendment right. Protest all day in
a lot
writing.
simpler, folks.
But that isn't what they did. They called themselves the duly qualified electors for the state of
Well,
Nevada,
they are if they'd have won.
but they didn't win. And the election contest had ended and said they didn't win. And that's what mattered. That's what happened at December 8th. And on December 14th, they said otherwise. They executed the documents and they mailed them. And then afterwards, their intent before and their intent after was to have their votes be considered. And it's reflected in the documents that were presented to the grand jury.
But being considered doesn't rise to the level of trickery.
I think that it does, because if those had been considered, if he had said, I don't know who won Nevada, so I'm throwing those out, then those 6 electoral votes go away. That has a significant impact to our election system. That can't be allowed.
I can't imagine that would happen. I mean, I think it's a little unrealistic. All right, anybody else want a last word? Anything else? All right, folks, I'm super tied up the next month, so it's gonna be a minute after that, 60 to 90. Can I get back to y'all?
Yes, yeah.
Your Honor, if it's possible to have it by sometime in June, I know that it's just that I think that it would be nice if there was a decision, because this has been going on for a while, and I think the reality
Whose
is,
fault is that?
wow. I don't know.
I tried to end it a long time ago.
Well, I'm not going to say anything, but be that as it may, I anticipate that either side, however the court lands, will probably appeal again. I mean, that's been a discussion that has happened, so just trying to keep it moving.
And I would, like I said, I will as soon as I can, but I got a lot, and I to be honest, I can't even remember, other than it's overwhelming, how much I have to look at. Okay?
Thank you.
So,
Are we setting a status check or just waiting for the decision? Because,
no, we're gonna set a status check, but what I'm gonna do is, after we look and see how many videos, how long the transcripts and everything that I have to look at are, get all the cases pulled, that I wanna reread, I'll give you an estimate. I'll try to do it in 60 days, where does that put us?
Like mid, or June, like June.
You guys like Fridays?
yeah, Your Honor, Mr. Wright and I are still in that federal trial. We just finished week 3. It's expected to go potentially 15 weeks. So if we could do
Whoa.
either, yeah, it's that MS-13 case.
I'm feeling better about my life right now.
If we could do a Friday,
Fridays are
if
fine.
it's before the end of June, if we could do a Friday.
That's fine.
Typically, you guys don't have things on Fridays. And so it
Friday's
seems
fine.
Seems to be the least conflicted. You want to pencil it in for, you want June, what's the end of June?
June 26th, it's the last Friday in June.
Let's pencil it in there.
I
So-
think I will be out.
Out? Great.
I think I'll be at the state bar convention.
Oh, I want to be too.
So could we do July 3rd?
I know.
Then July 3rd would be the next one.
It feels like a.
July 3rd's a holiday.
The 3rd is the holiday? Okay.
Yes, can you do are we able to go, oh, no, June 19th is also a holiday.
Yeah, June 19th is also a holiday.
Gotta love Friday holidays.
And I'm gone, I'm
July
gone,
10th.
July
I'm
10th
already-
would be the one.
I'm gone the next few
Oh,
July.
it's in trial.
Yeah, we'll be in July 10th. So if we could do,
I think that's why I'm saying I really feel like we have to be before, that's my feelings, I know that's not the court's feelings.
well, hold on, if I could,
I'm
I
afraid
know,
this case is
Is
gonna
the
go away
12th
before
of
you
June
guys.
the 12th of June would be 60 days.
Your Honor, with regard to that, I know that our trial is dark because our judge is on vacation the week of June 15th. So if we did like a different day besides a Friday, Mr. Wright and I could be here that week.
That's fine.
What was, what was the 26th, that was the, state bar, right?
I'm not sure. Let's just set it for the 26th, Your Honor, and if. I have my phone on.
26 should be fine. I don't see it.
I might not be able to go anyway, Your Honor.
But I think I am. You kind of need me.
What days are the conference days? Can someone Google the state bar conference, which one is it? I don't really understand this.
I have the state bar conference the 19th.
Oh, there we go, so that date works perfectly.
So let's do the 26th then?
Yep.
Okay.
I apologize for the confusion, I didn't have my phone on.
Right.
At what time?
Noon is good?
Is this likely just the court rendering the decision?
Yeah, I'm hoping I'm just gonna,
I don't know that our positions are gonna change.
no, I don't. Like I said, I need time to go over.
And Your Honor, just with regard to the exculpatory evidence, if the court release the reply.
That's when I want to go back and look at, and again, now I have to compartmentalize my thought process to see. Because at the end of the day, I don't think there's a chance to fraud, but the burden is so low.
But it's still a burden.
It still has to be weighed in favor of guilt, Your Honor, and it's not.
Thank you.
Thank you.
I don't know that I disagree yet, but I'll let you know. All right, we'll see you at the end of July, guys. Thanks so much.
Did we have a